Okay, I'm running a little late here, so we're going to skip the hellos and pleasantries. We're going to go over yesterday's bankruptcy hearing for Ronn and Jan's bankruptcy case, which did not go well for them at all. In fact, it was kind of like the walls were starting to close in, which I would call it kind of glorious, actually. Jan at some point tried to bring up an online smear campaign, as that has anything to do with her dumbass decisions regarding her finances and possible fraud. The judge did not seem like she was having it from the notes that I read. However, I have not actually listened to the audio on this, so I wanted to wait and do that now. I will be with Big Tiff, Dog, and Patrick, I think, and Bacon Bears after this. Briefly, so when this stream ends, it'll redirect you over there, and I'll be with them. But the reason I'm doing this right now is because I needed to try to do a short one on this. And I'm probably not going to be able to stay the whole time over there. I have to cut out at some point tonight. So I just wanted to make sure I get through the whole thing. I'm going to speed it up to 1.5 speed in the beginning. This is like a 30-minute hearing, and we'll kind of speed through the first part. And then when it gets to the more interesting parts, I'll set it back a little bit and we'll comment on that. The GoFundMe is finally going to come up here. The judge is not going to have it when they're trying to get this dismissed without those questions answered, which I think is wonderful. Of course, Jan, will probably try to blame this somehow on me and others online and say that that's why this is happening to them. But the truth is, this is happening to them because they are criminals, enabling their criminal daughter. I listened to those most recent episodes of Love Trapped where they tried to double down on supporting Laura as if they totally believed she was pregnant, but they know that Laura used her sister's ultrasounds to try to convince journalists and others that she was pregnant. They know that she fabricated medical evidence, and that's just in Clayton's case. So like, these people know. They know what they're doing is wrong. This is not like some sort of group delusion. It's a crime. Is a family supporting their daughter who's committing crimes, and they're committing crimes themselves, from what I can tell. In my opinion, that's what's going on here. So let me pull up the hearing from All the Best Research. Thanks to them for grabbing that and posting it, and even for the visuals here. One question I have is, why do Jan and the judge look like twins? That's kind of interesting, but they are cartoons, I suppose. All right, let me... This should be good on the view there. And I also put the link to All the Best Research video here in the description of this video. So if you wanted to watch it all the way through yourself, you can click that and it'll take you right there. All right. Hey Jack, what's up? I've written a lengthy letter. God, that poor mortgage company. Yeah, dude, it's the mortgage company that's doing something wrong, I'm sure, though. For sure. All right. Like I said, I put it up to 1.5 speed in the beginning here just so we can kind of move it along a little bit. So they might be sounding like they're talking a little fast, but I will move it back to normal speed once we get through this beginning.
Yes, I am Elizabeth Naylor Owens, appearing pro se along with my husband, Ronn.
If you don't know, Elizabeth Naylor Owens is her official legal name, I suppose. She goes by Jan Black, Elizabeth Naylor. She has lots of names, and Laura herself tried to change her name at one point during the course of what was going on with Clayton. Did not work out. People found out she was trying to change her name to Emily Wilson, and then she tried to get a refund. So that was a really interesting decision. Like mother, like daughter, though. More and more as this goes along, I agree with what Clayton has said. Jan does seem to be the ringleader of this crime family, I would call it.
Ronald Stephen Owens, also pro se.
Thank you.
I'm Ronald Owens.
All right, thank you. Good afternoon.
Good afternoon.
Good afternoon.
I'll take other appearances, please. Oh, Mr. Imo, you're muted.
Sorry about that. Good afternoon, Your Honor. Jennifer G. Imo on behalf of the United States Trustee.
Thank you. Good afternoon. All right, any other appearances? Nope. All right, let's go ahead and get started. This was the time set for the court to consider on a continued basis the debtor's emergency motion to extend the automatic stay. Since that last hearing, let me just roll back and say that at the last hearing, the court did temporarily extend the stay under 105 and 362 and directed that the debtors complete their filings in this case. There were schedules and statements filed, but they were replete with error. And also the debtors need to provide information to the Office of the U.S. Trustee.
So their filings, unsurprisingly, were replete with error, as the judge just said. And I'll let me put it back to normal speed, just so we don't miss anything important here. There's a lot about bankruptcy cases that I obviously don't understand that Tiff is going to be able to explain to us. Patrick, who's an attorney, will be able to explain some of this as well. We were talking about it last night, Patrick and I. We play Fortnite together a lot, so we're talking about this kind of stuff in that context. But let me pop that back to 1.00. So if there's any questions you have that I can't answer here for you, because to be honest, this stream that I'm doing here is just to observe the circus. But if there's any educational kind of questions that you want answered, that'll be in the stream after this one that you get redirected to when this is done. So no, please stop that. Okay.
That date has come and gone, and the last I checked, there were no papers on the docket to satisfy those requirements. I did, however, see that the debtors filed a motion to dismiss this case. They lodged an order of dismissal, and the Office of the U.S. Trustee filed a limited objection. I do see from the docket that the trustee's office has continued the debtors 341 meeting, so it sounds like that's not yet concluded. I'll tell the parties, with respect to the motion to dismiss the case filed at 57, it was filed along with, just as I indicated, a notice of lodging order, but that would be procedurally incorrect. In a Chapter 11 case, motions to dismiss must be noticed out to the master mailing list. I believe it's a 21-day notice. It's unlike a Chapter 13 where a debtor has the right to dismiss their case at any time. Chapter 11 doesn't work like that. So I did want to, at the first instance, Ms. Neidigh and Mr. Owens, tell you that the court has taken no action on your motion to dismiss because you have not noticed that out, I don't believe, to the bar, or I'm sorry, to your creditors, nor have you asked for a hearing or undertaken any other procedures that would allow the court to take action on your.
Basically, they're trying to take a lot of shortcuts, and they're skipping a lot of steps that are absolutely necessary for them to take. And as you're going to hear, when they talked to Jennifer, who represents the DOJ here, they had worked out an agreement to the motion to dismiss with a 1-year bar to refiling, to where they couldn't do this again, which this was a Hail Mary to save them from losing their home, in my opinion, based on the evidence that we have and the timing of this. But she would then, if they went with her agreement, ban them from refiling for 1 year. And they're trying to get out of this and saying we can just dismiss it. Now, the judge here is explaining why they're not going to do that. They didn't give the creditors any notice as they were supposed to, and they didn't, request the hearing as they were supposed to. And I'm not surprised by that at all. And Jan here will try to say probably at some point that it's because they don't have an attorney, blah, blah, blah. But they knew that they weren't going to have an attorney, and this was not something they were serious about. From what I've observed, I believe that this was just a stopgap, and they think they can continue to abuse the system over and over again, which this judge does not sound like she's going to be too interested in allowing. So,
your motion to dismiss. So from the court's perspective, that's where we are procedurally. I understand that the debtors no longer wish to be in this bankruptcy case. The U.S. trustee has asked that any dismissal be with prejudice and has a bar to filing for the next year. Often in these circumstances, the parties come to an agreement. And I guess that is my first question after that long introduction is, have the parties come to an agreement?
Yes, my understanding is that we have.
Okay, Ms. Jamo, do you want to tell me about that?
Yes, Your Honor. So I spoke with Ms. Owens, and then I did call the case in the 341 at the time of the 341 meeting, and we have it on the record that both Mr. and Mrs. Owens, both debtors, agree that the case will be dismissed provided that they are barred from refiling in any bankruptcy court for a period of 1 year. I have sent, just today, I sent to the debtors a proposed stipulated order of dismissal. And then I was going to ask Your Honor at this hearing if we could set the matter and have the debtors notice out the dismissal motion. And then hopefully if nobody responds, we can vacate the hearing and upload the stipulated order of dismissal.
All right, from a procedural perspective, that makes sense to court. The question I have, though, is at the last hearing, I heard a lot of information about ponies and GoFundMe accounts and other potentially.
Oh my God. How is this real life? Oh, I'm sorry. I heard a lot about ponies. I mean, these people are a mess. Oh.
Non-disclosed assets, which leads the court to believe that there could potentially be non-exempt assets that could be recovered should this case be converted to a Chapter 7, and a Chapter 7 trustee had the opportunity to investigate and to potentially recover and liquidate those assets for the benefit of creditors. And similarly, if there has been a fraud upon the court or otherwise, whether the debtors could be denied a discharge, and that might be
Nay!
something that a Chapter 7 trustee would look into. And I didn't see that that wasn't addressed in any of the parties' papers. And I don't know if there's been a conversation, Ms. Jarmo. I don't know if you've had an opportunity to undertake that analysis, but it seems to the court that it would be remiss to not at least explore whether it makes sense in this case to not just dismiss the Chapter 11, but to consider whether it should be converted to Chapter 7, where a Chapter 7 trustee can administer whatever assets might exist and potentially pursue fraudulent conveyances and transfers. And I guess what concerned me was if we had this large sum of money within the last year for the GoFundMe account, that seems to be an asset that could be potentially recovered for the benefit of creditors if it was.
But Your Honor, that was for Ron's medical bills. Totally not for my daughter's private attorney after she committed 14 felonies and got caught for those.
Paid to one particular creditor, say the mortgage company, that money should be recovered for the benefit of all the other creditors. And so these are the thoughts that.
For the record, as a donor to Ron's GoFundMe under the name Chase J. Jones, I personally am appalled that my money was not used for his medical bills. Just putting that out there.
That came to me as I read the parties' papers. I don't know if anyone would like to address that.
I can address that, but if the debtors want to speak first, I'll wait my turn.
No, go ahead and address it if you'd like to.
Okay. So yes, Your Honor, we absolutely thought of those things, and I appreciate Your Honor bringing them up because those are very crucial issues. In fact, my initial analysis of this case, I saw that the writing on the wall was going to be likely a motion to convert or dismiss and likely conversion. However, regarding some of the assets, I know that there was discussion about some horses. The debtors have a daughter, Laura Owens, who had previously filed a Chapter 7 case, and that case has since been dismissed, but I spoke at length with the attorney, Terry Dave, the attorney for the Chapter 7 trustee in that case. And my understanding was that there was not any feeling that there were really going to be collectible assets that were worthwhile to pursue for the benefit of creditors. And I know that it was the same companies that are owned by the debtors and that were disclosed in this case. Now, the GoFundMe, no, that would have required further investigation on my part, and it was something I was going to pursue in the Section 341 meeting. I think that this outcome is probably the best right now. There's no other creditors, not even the banks have come in and said anything, which I was a little bit surprised about. But I do think that if the case is dismissed, provided that they do not file for a year, then these financial matters will sort themselves out. So it's the U.S. trustee's position that this is a good outcome, provided that there be a bar to refiling. If the court is not inclined to grant it, then absolutely we would take up the 341 again. And I would say that in all likelihood, we would be back before Your Honor, asking for a conversion.
All right. Thank you, Ms. Jarmo. And I guess the way to.
And this attorney for the DOJ, she's done a wonderful job, I think, operating with the information that she has, and she's really put the pressure on these people. However, I think some people were unsatisfied with the way that she was expecting that this was going to go. But the thing is, the DOJ, they have to operate based on their resources and what's worth pursuing based on their knowledge. And that knowledge cannot be probably obtained through like reading social media and stuff like that. So there's a lot that the DOJ doesn't consider when looking into these things. The court can't consider when looking into these things, that other people who have been following this all along may feel outraged, like, how dare you consider letting them out of this? But like, the thing is, they have to operate based on what's legally admissible and sound and what's presented to the courts. And so I just want to point that out there. I don't think, from what she just said there, based on the information that she had, she thought this was a reasonable outcome. I am, for one, am glad that the judge did not find that to be a reasonable outcome. And we're going to see how that goes here.
To maybe tease that out a little bit is to go ahead and get that motion to dismiss noticed out to the creditors and others. I guess what concerned me was just looking at the docket, there was the motion to extend the automatic stay, which was opposed by the secured creditor. And then curiously, the secured creditor withdrew that opposition, which suggests to me that perhaps funds were accumulated and paid to the secured creditor. Which is
we
why
dug up that hole under the horses and paid them off.
Then that would be a classic preferential transfer.
More than ponies in those stalls, ladies and gentlemen. I think there's a 6-foot hole full of cash down there. Not really, I'm being dramatic, but like, if that was curiously, as she says, withdrawn, kind of sounds like they got paid. Kind of sounds like they got paid. And it kind of sounds to me like they are transferring funds between possibly their other daughter in a way that is untoward and dishonest, and suggesting that they don't have any assets. But that's just my speculation. But if they suddenly acquired the funds, or somebody else, wink, wink, nod, nod, somebody else who didn't mind lending their ultrasound to somebody to commit crimes, also lent them some money to pay off that debt, something's going on here. It's a little fishy. Let's figure it out.
That would be an asset to be recovered for the benefit of all of their creditors. And so I think that's something we should get some better understanding on before the next hearing. So that's what the court's thinking. And so again, I'm inclined to give you an opportunity to notice out that motion, because I'm not going to grant it here today. Your creditors need to have the opportunity to understand that is what you're looking for. But what do you want to tell me, Ms. Neidigh?
I was going to tell you that no funds have been transferred. And with regard to the GoFundMe, which I'm sure you were notified by the online smear campaign that was run against us. So
let me just interrupt you to say that the court only reviews what is filed with the court. So I know you referenced an online smear campaign before. I really have no idea what you're talking about. All I have is what has been filed on the docket and what people tell me in open court. I do not independently go out, and it would be unethical for this judge or any judge to go out and do background research on people and learn about them.
So and it's funny that she's saying that, right? Because Jan and Ronn and Laura and together with David Gingras had no problem trying to slander Judge Mata. Hold on, my phone's going off real quick. Shut up. Okay. So they had no problem trying to slander Judge Mata after Laura lost her case, trying to suggest that she did some sort of independent background research based on social media. And this judge here is shutting that down like, hey, I have no idea what you're talking about, lady. Take off your clown shoes. It's time to face the music based on what's been presented in this court. You're not going to be able to blame, Lauren, who put on a red turtleneck and called your daughter a bitch a bunch of times. That has nothing to do with your bankruptcy case, right? So we're going to just move on past that, and you can tell me why it seems like you're committing a bunch of fucking crimes. Cool.
Just so you know, that's the way the court will operate.
I'm not suggesting that. I know that the smear campaign people have said online that they have sent information to your office. So I don't know whether you've received it or.
Hey, baby girl. So if you listen to anything that she was just saying, she doesn't investigate independently. So she's not going to be accepting emails from random people, no matter how well-meaning those random people may be. And you know what? I don't send information to lawyers related to this stuff. I definitely don't send any information to judges related to this because I know that they can't consider that stuff. I don't know how the DOJ might be able to consider that stuff, but I sincerely doubt that the judge was just like, hey, I got an email from Bruce from Oregon, and it says Ronn's GoFundMe is a sham that's been used to buy Domino's pizza so my daughter, who's allergic to gluten, can fake a big baby belly. All right? I don't think that's what's going on here. So fuck off.
or not, and I know that they also sent it to the U.S. Trustee's office. But with regard to the GoFundMe, as I mentioned before, it was started in 2024, and all of the funds from that were exhausted by, I mean, with the exception of maybe, I don't know, a couple $100 or something like that, were all completely exhausted by the time that we filed Chapter 13 last August. That money was used, and in fact, the GoFundMe was started in part to try to prevent this bankruptcy and the Chapter 13 that we'd had to file last August. To try to get the funds. And at that point, some of the funds from the GoFundMe were used to pay mortgage at that point.
Now, Jan, honey, I don't recall you writing on this fundraiser here. Yeehaw! Saddle up, partner, because we're about to look into what you wrote in this GoFundMe. All right. I don't recall you writing anything here about your mortgage. Right? So they put up this GoFundMe that says Ronn is facing profound challenges with Parkinson's disease. They wrote about cancer. They wrote colon cancer most recently, serious heart issues. These medical strolls have taken a toll both physically and financially on the man who had been a pillar of strength for so many. Now, I don't see anything about the mortgage here, but I suppose they could maneuver this to make it sound like that includes their monthly bills because they say both physically and financially. However, let me pull this back up on the screen. What they don't write here is anything about their daughter's legal bills. Their daughter's legal bills. Is it possible that this wasn't used to pay any medical bills or mortgage, which, to my understanding, somebody can correct me if I'm wrong based on the documents, she has not paid the mortgage in quite a long time. So it doesn't make sense that this went to the mortgage. It is quite possible that it actually went to Joshua Colesrud, which, in my opinion, kind of sucks for Josh Colesrud because, he didn't know exactly what was going on here as far as their GoFundMe potential fraud, which I totally believe is fraud. I kind of think maybe it went to Josh Colesrud's office, and now Josh Colesrud is probably going to have that money clawed back, and he's going to have to be named as a creditor. It's possible. And just letting you know right now that part of this money was almost certainly spent on Jan Elizabeth Naylor Owens Black Sassafras Emily Wilson's clown school tuition, because that is the only way she could sit in front of this judge and say what she's saying with a straight face. And I know we can't see the hearing right now, but the hearing was accessible. And while there's no video available right now, you can see that she is fully committed to saying this with a straight face if you attend those hearings, which I didn't listen to the whole thing, obviously, but I saw enough. Honk, honk. Okay.
It was all virtually exhausted by, I would venture to say, by May of 2025. So that's why it wasn't. We didn't mention it in the Chapter 13 filing because it didn't exist.
Because it wasn't.
Well, transfers that are made
Shut the fuck up.
shortly before the bankruptcy.
Shut the fuck up. You used this money to pay off your daughter's private attorney. He ditched you guys once you didn't have the money to come up with the second half after she was charged with the second set of felonies. Fuck you. You lied. And I want my money back. Chase J. Jones, who donated to Ronn's medical bills. Okay?
Filing do have to be disclosed. That it's problematic if you did not disclose the use of those funds. I'm going to order and direct that you provide the records concerning that that particular issue to Ms. Jaimo so that she has an understanding as to the financial circumstances immediately preceding your prior case and this case, so that her office and the court has a full understanding of the circumstances before the case is dismissed. Because the court does need to make a determination whether best interest of your creditors would require conversion rather than dismissal. But at this moment, the court will not make any such determination. And again, the only information I have is that which is filed with the court and that it appears on the court docket. I don't believe I have any communications on the court docket from other parties, only the filings that I've seen from you and the U.S. Trustee's Office and the creditor. I believe that's all I've seen on the docket. Okay. Okay. Do you have any questions about the information I'm directing you to turn over to Ms. Giaimo?
If you could just outline it again so that I can take a note on it.
I'm really asking for a full accounting of the GoFundMe account, the monies that were received and the monies that were spent and how they were spent. And so, the whole typical information, what did you get?
I don't understand.
What did you do with it? Where are your receipts?
Okay.
Okay. The who, what, when, where, why, and how. Okay.
Hey, little lady, it's time to pony up those receipts for that and for the ponies you sold. All right.
Okay, but again, that was all prior to the Chapter 13, that if we'd had those funds, we wouldn't have needed to file Chapter 13 or Chapter 11.
Okay. Well, I hear what you're saying. Some transfers can be recovered despite the passage of time. This case was filed on May 22nd of 2026, and it could be that if there were funds that were transferred in a particular period, they would be of interest to the U.S. Trustee's Office. Okay. And let me ask Ms. Giaimo whether there are other information. I know that I had directed you to email to Ms. Giaimo the information required for the initial debtor interview as well as the 341, and I don't know if that's occurred. I believe that should happen before this case is dismissed. I think we should have a fulsome understanding of your financial circumstances. So I'm going to order and direct that you provide that information to Ms. Giaimo's office. Everything that you're supposed to be providing, you need to provide. So whatever that office is asked for, I'm ordering and directing you to cooperate and to provide that to her.
Your Honor, we were unable to do that. I had presumed that we would be able to get counsel to help us. This was never my intention to file pro se, and I'm very...
Bitch, what are you going to do? Start another GoFundMe? I got a hangnail. Give me another $140,000 and I'll pay another lawyer with it so we can go through this bankruptcy. Fuck off.
Aware of the fact that Chapter 11 is a very exhaustive chapter to go into as a pro se litigant, and that was not our intent. Our intent was to be able to get counsel, and we have been unable to obtain counsel.
Well, I intended to be a billionaire by the time I was 25, but shit doesn't happen like that, does it?
You know your financial circumstances best, and so you should be able to reconstruct that information and gather those records to provide it to Ms. Giaimo.
But Your Honor, I'm unable to without adequate counsel. If I had been...
Jan's never been hit with anything adequate in her entire life. She wouldn't know adequate if it hit her in her fucking face. All right? I don't want to hear it. All right? They knew that they were going into this without counsel. They signed papers saying that they were doing it pro se anyways, and they did it to stall the foreclosure on their home. And this judge is not going to allow them to indefinitely postpone that just because they're a bunch of uncaught, fraudulent assholes. Oh, no. Maybe sell some more ponies or something. I don't know how else you're going to pay for your legal fees, but you're kind of screwed here.
Able to do that on my own, we would have continued this on our own.
Right, but you filed this case. You filed a Chapter 11 bankruptcy case. You have not yet paid the full filing fee. And once you're under the jurisdiction of this court, you have to abide by the United States Bankruptcy Code and its rules and requirements. And I'll tell you, one of the most important things about the Bankruptcy Code is it requires absolute transparency. And that's the concern of the court, is that the schedules and statements here compared to the prior schedule statements seem to indicate a lack.
But Your Honor, my daughter has an HCG level of 85. That makes everything all right. Not that she purchased it illegally, but that's somehow evidence of everything.
Of transparency. And so As a participant in the system, you have certain obligations, and I'm directing you to fulfill those obligations. And when we return for the next hearing, Ms. Amo can give me an update and let me know what she's been able to learn. And it could be that a dismissal is still the recommendation and will be the course of action. But it's not appropriate to file bankruptcy and park in bankruptcy and obtain the protections of bankruptcy and yet not fulfill the obligations. And so again, that is your obligation. You filed this case. You undertook these duties and responsibilities, and now I'm directing you to cooperate. All right, Ms. Jamo, anything you need to add?
I just want for clarification, Your Honor. So the noticing of the hearing on the motion to dismiss, at which we'll discuss what happens in the interim, is that something that the court is going
to answer the question at the bottom of the screen here? Apparently, that I've been called such multiple times by Deadpool's wife and this clown lady here on the bankruptcy hearing. So it must be true, right? You know.
notice out, or are the debtors required to do that?
The debtors should be noticing it as a Chapter 11 case. Let me ask the court deputy if there's any provision for the Chapter 11. Generally, in Chapter 11, those debtors undertake the noticing. Do they do that?
They do, Judge, but we can if we need to.
Okay.
Yeah.
Okay, so I can see where this is going. They're probably going to blame the disabled dogs that they adopt next. Just saying.
Take a look at the master mailing. Let's see how big it is. We're going to take a look at the master mailing list. Just a moment.
Doesn't give me a number, but I would, if I had be about 20.
Okay, that's fine. The court will go ahead and notice out the hearing on the motion to dismiss. Okay, so the court will take care of that. We've got access to the master mailing list of creditors. And so the court will go ahead and notice out that hearing. Ms. Jaimo, I saw that you had continued the 341 to July 16th. I don't think that gives us enough time because this is, if I recall correctly, a 21-day required notice. Just a second.
Thank you, Jennifer Cottrell 71 for that. We'll probably skip up a little bit here.
Enough for the court.
Let's move back over.
It's a 21-day notice. So let me turn to Ms. Hall and ask for a hearing date and time, please. Enough for the court to utilize the BNC.
Yes, Judge, that will be Thursday, August 6th at 2:30 p.m.
So that's Thursday, August 6th at 2:30 p.m.
Jan will accuse that nice lady with the meek voice of being a JFC plant. Just my prediction, based on her daughter's behavior, which she learned from her clown mother.
Any questions or concerns from you, Ms. Naylor or Mr. Owens?
Well, I'm a little bit confused. So I have to send out the notice of dismissal, or what?
So the court will do that for you. The court will send out.
Wait a minute.
It's highly unusual. Any Chapter 11.
We gotta go back a few seconds here. I turned on the closed captioning just in case people needed it. I just like I have to send out the notice for dismissal. Snorts. I didn't actually hear a snort there, but sometimes the closed captioning mistakes are pretty funny. Hang on. This is why I'm going over time that I meant to do, because I get distracted by this nonsense.
The notice of dismissal, or what?
So the court will do that for you.
Yeah, there was no snort there, and that's why I would have you people remind you people to watch the video and not just read transcripts, because she didn't actually say notice for dismissal. Okay, that's not what happened, right? And that actually hurt my face, so I'm gonna stop. I'm gonna stop doing that.
For you, the court will send out. It's highly unusual in a Chapter 11 situation. Generally, the debtor or debtor's counsel sends out the notice of hearing. The court will do that. The court has set the hearing date for August 6th at 2:30 p.m. The court will send out the notice for creditors and parties in interest who might wish to attend. Within that notice, we'll also be advising folks if and when they'd like to file an objection when that's due. And this will give Ms. Jaimo an opportunity to receive the papers that the court has directed you to give to her in connection with the IDI and the 341. I'm not going to hold those deadlines in abeyance. You were previously ordered to provide them. You haven't provided them. From where the court sits, you're currently in contempt, ma'am.
Oh, I understand.
Oh,
I understand.
baby, can I get this is the ESPN replay here. Can I get a replay on that? Hang on.
31. I'm not going to hold those deadlines in abeyance. You were previously ordered to provide them. You haven't provided them. From where the court sits, you're currently in contempt, ma'am.
There's the Procedural highlight.
I understand. Okay.
Okay. Any other?
Well, okay, little lady. I'm going to go consult my ponies about this one. They think they're worth more than you and the bankruptcy court evaluated them at.
Other questions or concerns, Ms. Naylor or Mr. Owens?
None for me.
Okay, thank you. Ms. Jaimo, anything further? I'm sorry, Ms. Naylor, did you have a question?
Well, the foreclosure date has been set for July the 28th. And I have filed some objections with the lender to the mortgage
Where else will my ponies live?
lender to see what can, and I would like to hire an attorney to handle the foreclosure. So I'm just wondering about how those dates coincide.
Bitch, I would like to have more money to spend on pie and clown shoes, but here we are. All right, you got to pay your bills. You don't get more. I would like to have more. I would like to hire I would like to hire a butler and a maid. I don't get to do that. And I don't get to avoid my creditors because of that. What a whack job.
My hope was to retain outside legal counsel to resolve the debts with the mortgage lender and also the unsecured creditors outside of Chapter 11. So that was what I had hoped to do before.
The only people that Jan and Ron are paying is their broke-ass daughter and her sister, who's, in my opinion, probably hiding money for them. Okay, so that isn't what they mean by unsecured creditor. It doesn't mean insecure criminals, right? But like that's where we're at, I guess.
Before July 28th. So with this date being set of August the 6th, I'm a little unclear about the overlapping.
I don't really understand your question. I mean, the court has set a hearing on August 6th, and you said you have a foreclosure on July 28th. So yes. I bet I don't understand what your question is. You stated facts, but what is the question?
The question is, if the hearing is set on August the 6th, how does that impact foreclosure on the 28th? Because there's no, we had asked if the stay could be continued.
And this is how you know that Jan misappropriated the GoFundMe money to pay for her clown school, because you don't learn this shit until the third semester. All right? That's advanced clown bullshit.
I see what you're asking is if the court would be inclined to extend the stay that's temporarily in place.
Correct.
Is that what you're asking? Okay.
Correct. Just
to
allow us to sort through all of this.
Ms. Jaimo, do you have an opinion?
Yes, Your Honor. The U.S. trustee objects to the extension of the stay. I mean, this is precisely one of the reasons that the U.S. trustee considered the case to be
advanced clown bullshit. That's right. Talk about a court jester, ladies and gentlemen. Woo! Woo!
filed in bad faith and an abuse of the system. I believe that the debtors have not paid their mortgage to the tune of $191,000 of arrearages. And while they're seeking the benefit of the stay, they haven't complied with the obligations of the bankruptcy court to justify getting the benefit of the stay.
All right. Do you wish to respond, Ms. Naylor or Mr. Owens?
Well, we have filed letters with the mortgage holder. We believe that there are very, very serious issues that the mortgage holder needs to address with regard to this.
It's very serious, Your Honor. The mortgage holder didn't believe that my daughter's HCG level of 5 meant that she was pregnant with the bachelor's twins. And therefore, we had to spend all of our money on lawyers. And now we don't want to pay any of our creditors. And we don't want to lose our house either. So can you just fuck off?
And we've filed lengthy letters with them and are waiting to hear back. We've been told that we will get a response. So we're kind of waiting to hear back as to what will happen there.
Okay. Well, there's two things in play here. Number one, if you have issues with a mortgage holder and you are making claims or assertions to them or about them, that's completely separate and distinct. That's not occurring in this court. So there's really nothing that this court can do to help you with those transactions with your mortgage lender. And I think you're communicating directly with them, so I believe you understand that.
I'm not sure we are communicating directly with them. I mean, it's been very, very difficult.
I just told you, it's a JFC plant, guys. I just told you. Their mortgage lender is actually my cousin's husband's daughter's friend's father, his cousin's second girlfriend's mom, who is currently buried in the cemetery. That's it. That's the logic we're using here.
To get to the people that we really need to get to. That's been one of the issues. There seemed to be a lot of
See, the problem we're having actually is that that lender that I just mentioned, the one that's buried, was cremated. So the ashes are being used to sign JFC papers. That's actually what's happening here. And these people are rich, and you shouldn't take their home away. It's not their fault. Their daughter got pregnant 14 times and killed off 7 fake babies and then went to the press.
Folks at play here. We get told one thing by people that we have spoken to on the phone with the mortgage servicer, and we get the very next day we get a letter in the mail saying you have options, we can modify things. So it's been very much up in the air. We get a bill that says that the monthly mortgage is due, and then we get another thing in the mail saying that all of the arrears need to be dealt with. So we really have been trying very, very hard for a long time to get this resolved and to get something in place so that we can move our lives.
You know, what you could do is stop spending money on attorneys to help your, insane psychotic daughter. Not actually psychotic. She knows what she's doing, who you taught to be a crazy psychopath, to not waste all your money on court fees that you will eventually lose when people realize that she's a lunatic who has done this to several victims and continues to abuse people through the courts. I don't know. Anything but accountability. Anything but accountability. All right, we're almost done with this video, guys. Don't worry.
Forward. And as I say, we have uncovered things that we feel are violations that really need to be addressed before a foreclosure.
And you know what's funny about that is we feel our violations. I feel Jan has violated me 14,000 times by making me listen to her slop. Okay? But, it doesn't make it a thing that I'm owed money for or should be not paying my bills for. Sure.
Could take place.
To the extent that you have claims or issues with the mortgage holder or the servicer, and I know sometimes it's difficult to understand, who to speak with, in particular
Right.
when servicing is transferred, it can be a bit of a challenge. But it sounds like those are issues that you have to take up directly with them. There's nothing pending before this court. This court can only rule on and consider the matters that are directly in front of it by motion.
You gotta rope in those matters, little lady, just like you do your ponies, all 40,000 of them that you have across many states.
Otherwise, so I can't really speak to that situation. And to the extent you want to assert claims, those are generally the types of claims that are asserted in federal court, outside bankruptcy, at the federal district court, or at state court. Or injunctions are obtained in state court before foreclosure. So I can't really speak to your situation with your mortgage servicer. I think you'll have to continue to deal with that and find a way to to connect with the appropriate individuals or to assert those claims in a proper forum. This is generally not that forum in bankruptcy court. So I'll answer you that. With respect to the pendency of the automatic stay, I have to agree with Ms. Jamo that at this time, there's no basis upon which this court should continue to extend the automatic stay. It, by operation of law, should have expired on or about June 22nd or June 23rd. The court did take the extraordinary step of looking at Bankruptcy Code Section 105 and to temporarily extend that stay so that you could perfect the papers that you've already filed with the court and participate in your 341. And
so basically, if you're lost here, she is saying that they did extend the stay on their home, even though what they did was just sloppy work, and the court went out of its way to extend that stay and give them the opportunity to fix this, even though they did the sloppy work themselves, knowing that it was sloppy work, right? But, you know, they're not going to continue to stay the foreclosure any longer. So this thing that's coming up on July 28th, the foreclosure of their home, they don't have any more. I think maybe they do have some creative Hail Marys in there, but it's not going to happen this way. The court's not here going to give them an automatic stay or an extension of the stay, because they've been doing some weirdo clown shit. We got like 3 or 4 minutes left here, so not too much longer.
And participate with the initial debtor interview. And unfortunately, those things have not occurred. The papers have not been amended. The U.S. trustee has not received information for the IDI, the initial debtor interview, or the 341. And so this court can no longer continue to extend the automatic stay. So to the extent that your motion to dismiss asks this court to hold deadlines in advance, the court declines to do so. And again, that motion is not technically before the court anyway. But at this time, during this hearing, which was set on a status hearing for your motion to extend the stay, the court's going to deny that requested relief. I cannot find on this record that there has been clear and convincing evidence, which is the standard, but I cannot find that there's clear and convincing evidence of a change in circumstances between the dismissal of the Chapter 13 case and the filing of the Chapter 11 case for the reasons that we discussed at the prior hearing. So that is the order of the court. I will put that in.
I thought she said prayer hearing. She said prior hearing with an accent, but prayer hearing would have been more accurate.
In the minute entry, which will be signed and circulated, and the court will also undertake the noticing of the motion to dismiss. And if there's, Ms. Jamo, so what I guess what the court would be noticing out is the motion as filed. And then if the parties want to work out the terms of their written stipulation, then that could be presented at the hearing. Sometimes that itself is noticed out, but it doesn't sound like you're ready to have that noticed out. Is that fair?
That's fair. Yes.
Okay.
Yes, I think that the best thing to do at this point is just to have the motion to dismiss noticed out, see what kind of response, if any, what responses are filed. And then also in the meantime, I can better evaluate what our position should be in light of the documents I'll be receiving and the testimony we'll be getting at the 341.
Okay. All right. Fair enough. Well, I think that concludes all business on the court's docket here today. We've set a hearing on the motion to dismiss on Thursday, August 6th at 2:30 p.m., which the court will notice out. And that notice will be given to all creditors listed on the debtors.
I just want to point out here, After Hours Respawn, which is it used to be known as MG Law. He's rebranded his channel. Says that was really no authority. There was really no authority to extend beyond 30 days. Requires the hearing. This law requires the hearing to be held and completed within 30 days. Section 105 is general in nature. 362 C3 is specific and controls. I think he extended his comment down here. Let me see if I can find the rest of it. Well, that might have been the end of the comment. I'm not sure. Oh, their mortgage and their mortgage arrearages are more than my entire mortgage amount. Huh. Well, that's a problem, isn't it? Anyways, if you haven't seen MG Law in a minute, he's right here. Just rebranded a little bit, and I'm glad to see him. We're going to listen to the last couple of minutes here, and then I'm going to take you guys over to Tiff, where I'll join her and some others to talk about this from a different perspective. These guys will be a little more dialed into the law and what that means. Honestly, I'm just here because sometimes you can sit and watch something and know that what somebody's saying is nonsensical. Like, hey, what you're saying, it's batshit crazy and it doesn't make sense right now. And I know that, and there's no way you're going to pull that over on me. And that's kind of how I feel about it when I'm watching these sort of hearings with Jan and Ron representing themselves. However, there is a little bit more depth to it as far as the law and how bankruptcy works that some of these other guys I'm going to talk to can tell you about.
Master mailing list, and we'll take that issue up then. With that, I'll ask one more time if there's any questions or concerns. Ms. Jamo?
Yes, just one thing, Your Honor. I just want to clarify for the record the deadline by which the debtors need to provide our office with the number one, the accounting of all the GoFundMe funds, and two, all of the documents that they already are on notice of being required to produce as part of the initial debtor interview. May I suggest that the deadline be set no later than Friday, July 10th, because that gives me sufficient opportunity to review the documents before the 341 meeting.
So that is
AHR says at 192K and mortgage arrearages is insane. Yeah.
I was just going to look at a calendar. That is a week from this Friday, which seems like it should be a sufficient amount of time. So, Ms. Naylor, I'm inclined to embrace Ms. Jamo's suggestion of Friday, July 10th to provide the documentation. Okay.
Okay.
All right. So it's hereby ordered that no later than Friday, July 10, the required documentation for the 341, the initial debtor interview, and the GoFundMe accounting shall be provided to Ms. Jamo's office.
The GoFundMe accounting is going to kill them. Like, they didn't anticipate ever having to answer that. I'm pretty sure that's going to be embarrassing. That's going to be hard for them to explain. So
we previously discussed that I would like those documents emailed in electronic form to her office, and that will be the order this time. Anything further from the parties?
I would venture a guess that Jan will not send those documents to the DOJ by July 10th and will blame it on not having an attorney. However, they don't have an attorney because they blew all of their money paying for their daughter's fraudulent court cases where they paid for expensive private attorneys and are now paying for private attorneys. I don't know where else that money would be coming from. I'm pretty sure, I feel like they are definitely the ones paying for Laura's private attorneys right now in her criminal case. So, like, sucks to suck, but you shouldn't have spent all of your money enabling your daughter to commit fraud against men who didn't do anything wrong except not want to date her, enabling that, her crimes, and participating in them is a costly venture that has now landed you in this position. I feel no sympathy for Jan. For Ron, I don't wish anything ill on him. I don't celebrate, any sort of issues he's having with his health. I think that's terrible. But, I can't say that I have a ton of sympathy for him either. Both of these people enabled Laura to abuse her victims and assisted her in doing so. They know that. They know that Laura lied, yet they go to the press even now and say, our daughter was telling the truth. We would support her 100%, while knowing that she was using their other daughter's ultrasound, that Laura used their other daughter's video of Ron touching Sarah's pregnant belly and cut off the head in the video to try to make it appear as if it were Laura. They know what's happening here. They've known all along. And I can't say that I feel too sad for them at this point, because they have used their wealth, or lack thereof, but the wealth that they borrowed from banks that they now can't pay back, to torment and abuse innocent people. And now they need to face the music. All right? Because sometimes it's nice to blow off steam and to make fun of what's going on here because, they're being stupid, right? But the truth is, it took a lot of awful, horrific abuse of innocent people to get us to where we are today, to where people needed to come in online and dig into what was going on and comment on it, because the media was refusing to pay attention to it, because the people that she was attacking and tormenting didn't have the legal or financial resources to deal with it. And so it's actually very, very sad. That being said, I choose not to be too sad about these people anymore. I choose just to make fun of them for being clowns, because honestly, carrying that around with you all the time, it makes you bitter, and it's not good, right? So it clouds your judgment. I think that I sometimes have been not myself when dealing with whatever these people are doing, including when they attacked me personally for speaking up for Laura's victims. I think that, you know, I don't always love how I've responded to that, but I did the best that I could at the time, and I'm doing the best that I can with it now, which is just to honestly make fun of them a little bit. And I don't feel bad about that. So, all right.
No.
All right.
Nothing from the U.S. trustee. Thank you, Your Honor.
All right. Thank you. We're adjourned. Good luck.
All right. Thank you again to my friends at All the Best Research. Let me show you their channel real quick. If you go, like I said, to the link in the description of this video, you can click on that video and watch through it yourself. I will also post a link to their channel in the comments of this video when I'm done here. If you guys could do me a favor, don't forget to hit the like button for me. It helps me out a lot. I'm sending you over to Tiff now, who I'll be joining. I believe she's with Bacon Bears, and Patrick will be there as well. I don't know if anybody else is coming in. I won't be able to stay the whole time, but I will be there for a little bit. So as soon as I'm done here, it'll redirect you over there, but I'm also going to post a link just in case. And I will be there shortly. I just need a quick break, and I'll see you guys soon. So thanks, everyone. Actually, let me read these real quick before you leave. If you sent me a super chat, I'm sorry. Stir Crazy, thank you for the 5. We all know where the money went. LOL, thank you for doing this, and thank you very much. I appreciate that. Jupiter Janes, thank you for the 5. Says, I love you. That is all. I love you too. Thank you very much. IB0093, thank you for the 5. Diddy Gilgo Hoboken stole the GoFundMe. Well, P. Diddy probably did steal the GoFundMe. Lady K Texas, TX $5. Thank you very much. Logistically, how could the smear campaign have anything to do with their finances? Dude, it has about as much to do with their finances as P. Diddy does, but here we are. Wendy Michelle, thank you for the 2. Judge, we want to live as squatters. I mean, I'll probably try that, yeah. Thank you. K Dubs, thank you for the 5. Want a full body exam, file documents in a federal court. Yeah, that's one way to do it, eh? And then I saw that Mary, I can't remember what her last name is now, but it showed up on her profile. Mary, thank you for becoming a channel member. Before I started the stream, it didn't save the comment there because it was before I started, but I did see that, and I appreciate you. So, all right, I'm sending you guys over to Tiff now. Please tell her I said hello, and I will be joining them shortly. She'll be able to answer any questions for you about bankruptcy and how that works, and so will Patrick. So, all right, thanks, guys. Appreciate it. And if you, like I said, leave a like and comment for me on this video, it helps a lot. Bye.